today that I have a text sitting in our text feed that's gone unanswered. That's very unlike you.
Yeah, we're live, Pete.
I know. We're talking. This is the personal stuff people show up for.
That's right. Whether I respond
That's
to your text, the answer is no.
This is great. Thank you. If you are here joining us for the live stream on Facebook or LinkedIn or YouTube, welcome. Remember, you can use the comments feature in those platforms, and those comments will be filtered into us as we record. So we're happy to take questions about this topic today as we go.
Can I just say something before we get started?
Sure.
I really like how your hat emblem matches
Mhm.
your shirt and your undershirt.
Yeah, it
The
does.
red and the green. Very nice.
I did not. I totally planned that.
Yes. No, you did not. There's two of us on this podcast, and only one understands fashion.
Yeah, and I have my purple watch band, ecclesiastical purple, pagan orange. I try to represent
All the above.
all of the above. Are you ready?
I'm ready. Let's do it.
Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, we're talking about your toaster's next gig, representing the best intentions of the smallest waffles.
Welcome to the show, everyone. I'm Seth Nelson. As always, I'm here with my good friend Pete Wright. Today, we're talking about guardian ad litems. Who are they? What do they do? Who do they represent? Are they on your side or not? What's going on with those people, Pete?
It seems to me that they are faculty at Hogwarts. That's what it sounds like.
Well, and thank you for joining us today. That's a wrap.
That's
You
it.
touched it. You crushed it.
That's
Yeah.
right. I'm a middle-aged white man. Let's talk about Gryffindor.
So it's a great concept, a guardian ad litem. And what they are individuals, neutral third parties that are supposed to help the judge gather information, come to court, write a report, come to court and say, Judge, here's everything that I learned. I did an investigation. I wrote a report. I talked to school teachers, to the kids, the parents gave me a list of people to talk to, babysitters, coaches, friends, grandparents, aunts, uncles, anybody that's seen you interact with the kid, right?
Mhm.
And here's what I think is best. Maybe they reviewed medical records. Maybe they reviewed school records. They talk to the child. They go to the home or the park or the zoo and they watch the parents interact with the child. And it's supposed to, spend hours and hours and hours of looking at all this stuff because, as we know in the court system, the judge doesn't have hours and hours and hours to do all this, right? And then you get the report, you put them on the stand, and they say, Judge, here's what I think. Sounds like a great idea, right?
Yes. Sounds like a great gig.
Couple problems.
Okay.
Check your local jurisdiction on this one. In Florida, the evidentiary rule called hearsay still applies to a guardian ad litem. And
okay, you're going to have to detail that.
Break that down.
Yeah.
We all know the word hearsay as people just use it in normal day life. But in the legal world, hearsay is a specific evidentiary objection. And that is, if I ask you as the guardian, Pete, what did little Johnny's teacher say about Johnny's school, how he's doing at school?
Mm-hmm.
The other side can say objection, hearsay. And here's what that means. I'm asking you what someone else said.
Right.
Right. So that's an out of court statement because I'm asking you what that teacher said, not in the courtroom, outside of the courtroom. And I am offering it in court because we're sitting in the courtroom now. Here's the trick: to prove the truth of the matter asserted.
But sidebar, please.
Yeah.
Counselor, if I'm the guardian ad litem, am I not operating as an agent of the court?
Yes, you're appointed by the court with a court order.
So why am I subject to hearsay? If I heard the teacher and took down that report of what the teacher said, why is that suddenly hearsay? I do not understand.
Right. Because the law doesn't make sense in this area.
Oh, good. Okay. So it's not just me.
It's not just you. The guardian ad litem is not deemed to be an expert. And if you're an expert, let's say you are an expert in appraising real property,
Mm-hmm.
you rely on hearsay in gathering your report, in gathering all the information you need to do an appraisal. Because what
Mm-hmm.
does an appraiser do? He looks at comps, other properties. He
Yeah.
goes through the public record. He looks at all this stuff, right? Those are all out of court statements that he's relying on for his or hers ultimate conclusions.
Yes.
The house next door sold for X. I
So
think
what's different about the guardian?
they're not deemed experts in Florida family law.
Uh,
So to start this, I
Experts
know,
in what? What would they be expert listening?
right? Helping children, like,
Right?
what they're asked to do,
Yeah.
right? So there's a push in Florida family law to say that a guardian should be allowed to rely on hearsay and bring that to court, because
Yeah.
this obviously does not make sense.
It makes no sense.
Okay. And the
Okay.
reason why I'm dealing with this up front, remember, out of court statement offered for the truth of the matter asserted. So when I ask you, how is Johnny doing in school? I'm asking you to say, oh, he's got A's, he's got B's, he's got C's, he's got D's.
Yeah.
And I'm asking the court to believe that. I'm offering that information for the truth of the matter asserted.
Yeah.
Okay. Now, I'm just going to give people a little evidentiary trick here.
Okay.
Okay. If I say to you, how is Johnny doing in his grades?
Okay.
And the other side says, objection, hearsay. And the judge looks at me and says, Mr. Nelson responds, I'm going to say, I'm not offering this answer for the truth of the matter asserted. I'm not offering it, Judge, to prove whether Johnny's getting A's and B's or to prove whether he's getting C's or D's. Judge
Okay.
goes, well, why do we care then? I'm going to say, I'm offering it for the effect on the listener. And you say, he has D's and F's. And then I say, what did you do next when you heard that? You say, I advised he get a tutor. So I'm not offering it that he really has D's and F's. I'm offering it because when you heard that,
Yeah.
whether it's true or not, it had an impact on you. And you then said he needs a tutor.
Okay.
You with me?
Well, I'm with you in I'm with you in practice and maybe not in concept, right?
Right.
What is who for whom is that statement made? The judge?
Yeah. It's made because it was a question in court by a lawyer and you're a
Yeah.
witness and you have to answer. And ultimately, it's for the judge because I'm trying to prove my case. They're trying to prove their
Right.
case. Okay.
Yeah.
So now people are like, we just spent 5 minutes talking about a guardian can't do anything.
Yes.
Now, there's exceptions to the hearsay rule. There's a lot of them. One of them is called a party opponent. If you're getting a divorce, you can say what your wife said or what your husband said
Mhm.
because they're a party opponent. So they're the other side of the V.
Right. So
Smith
as
v.
long as you're
Jones.
talking about people who are involved directly in the case, you can say what you heard.
Exactly. If you're the litigants, you can say
Mhm.
what they said and okay, no problem.
But the kids are not litigants, so you don't get
Right.
that privilege.
Exactly. So that's why people are like, well, it's hearsay. Well, yes, it's technically hearsay, but there's an exception to the rule and therefore it's admissible.
Yeah.
Okay. So in Florida, and I spent a lot of time on this because we're in Florida, before you go after a guardian ad litem, you need to check with the other side to see if they will agree to waive the hearsay objection because otherwise you're wasting your time and money.
Because everything that you do is going to be hand waved away as hearsay.
Except talking to the parents.
Yeah.
Because they're party opponents. Which means when they look at a document, the kid's report card, that's an out of court statement. It's a report card. It's stating what his grades are. They can't even come in and say he's got A's and B's.
Now, wait a minute. Doesn't that, if it's an official record of a school, can't that be entered as evidence?
It could be, but you have to call the record custodian of the school, and then you get it in, and there's a hearsay
Official.
exception for that. So yes, you can get it into evidence, but if you don't put it into evidence, they can't testify about it.
Okay.
So you have to get every single document
Yeah.
into evidence, right? But then remember, they've already written their report because under Florida law, it's due like 20 days before this, and that. There's all these rules. So the report's written. So you have to get everything into evidence on the guardian ad litem first that they relied upon. And then when you get the report in, they're going to say it's hearsay. And you're like, no, judge, nothing in here is what anyone else says. They only are going based upon the documents that are already in evidence.
Right.
It's tedious.
Yeah.
Okay.
Can we back up for just a hot second?
Yeah.
Can you explain the circumstances under which you would find a guardian ad litem should be appointed in a Florida custody case?
Perfect. That's right where I was going.
Okay.
It's almost like we planned it, but we didn't.
Okay.
So here's the deal. Why would you use a guardian when you need them?
Yeah.
Okay. So assuming you can get the hearsay done, this is where you have information and both sides are just saying, no, it's her fault. No, it's his fault. No, the kid, typical example, 14-year-old child not going over to mom's. Mom says it's all dad's fault. Dad's not making her go. Dad's bribing her with this. Maybe let's do it this way. 15 in 6 months, promised her to buy a car, right? Like,
Yeah,
does
right.
all this stuff. It's dad's fault, dad's fault, dad's fault. Dad's going to say, I can't get this kid to go. This kid's pissed off at mom for X, Y, and Z. Can't do it. Not getting it. It's not happening. Every interaction they have ends up poorly.
Okay.
So how do we know? We could bring the kid in. Judges hate that. And remember, in Florida law, there's 20 different factors. One of them is, do you shield the kids from litigation? Yeah. Okay, well, you bring the kid into litigation. That's not shielding them.
Shielding them, yeah.
Another one is the kid old enough and mature enough to have a preference? So those are in counterbalance with each other. So you get a guardian to go talk to the kid and be like, what's going on? Right?
Do you find in your relationships with guardians in these cases, do you find that the guardians do get someplace with the kids as a trusted third party?
Yes, and that is a skill set in and of itself, because even though the parents aren't supposed to talk about the litigation, they're going to have to say, hey, there's this person called a guardian ad litem that's going to come talk to you to hear what you have to say that represents you, right?
Because in what way do you interact with the kids, right, as the attorney?
Never.
Okay. That's an important distinction.
I have never spoken to a child in a custody case.
Right.
Never.
Because notoriously, you're known as just hating children.
Well, exactly. Especially my own.
Absolutely not true. Okay, so that's an important distinction, that it's the guardian ad litem can develop an important trusted relationship with the kids.
That's right. And they do it fairly quickly. And sometimes it takes some time, right? And then you want to meet the kid out of the office. You don't want to always meet them at the guardian ad litem's office, like, because some of the guardians will be mental health professionals, some might be lawyers, right? So you go to a law office. When does a 14-year-old ever walk into a law office, right? Like, that can be intimidating. So you got to build up the trust, and these guardians are really good at it. And then sometimes they'll exchange phone numbers and let them text and communicate with kids, let them know they're there. But they make clear, I'm here to hear what you have to say, see if we can solve any problems, so to speak. But really, I'm here to tell the judge what I think is best for you. But you get a voice. You get to tell me what you think is best, but I might challenge you on some of that. Like, I never want to go to mom's. Well, let's talk that through. Yeah. Have you tried this, and this, right? Right. So, and then the guardian can go ahead.
Some of what you're saying describes a relationship that I might expect a kiddo to have with a therapist.
Yes, but the therapy is protected communication.
Yeah.
With the guardian, it's not.
Okay.
Right? If a child is going to a child psychologist or mental health professional for counseling, that's all protected. You don't get that,
Yeah.
right?
Yeah.
And the concept there is pretty obvious. You want them to speak freely. They're not going to speak freely if they know if they say something to them and the person's going to turn around and say, I really like mom, but dad offered me a car.
Yeah. Right.
Right.
So that goes to the question of trust, though. Like the child knows presumably that their relationship with the guardian ad litem is public to the stage of the case.
Yes. And that's where building the trust is look, I'm here to advocate for what I think is
Yeah.
best, but you need to be straight with me.
Yeah.
But the guardian also watches the interaction with the parents and talks to the parents and sees all the filings and what they
Yeah.
say and all the depositions, and they review all of it. And they'll say to us as the lawyers, because they'll meet with us before they give the report and say, yeah, dad's the problem.
Mm-hmm.
He has manipulated this child, and mom then negatively reacts, and then it's the conflict, and the kid hates conflict. So the kid's gonna be like water and take the least path of least resistance, and the path of least resistance is not going to mom's.
Yeah.
And it's horrible.
Yeah, and boy, just hearing you say that, like, I can absolutely see why getting agreement on this hearsay thing is important, because you could just get hammered with objections, because if why would you trust anything that the guardian says
You're
if
getting
it
nowhere.
didn't go to your case? So let's drill down a little bit on impact on custody decisions, right? So assuming you waive the hearsay rule, how much weight do judges typically give to the guardian's recommendations?
A lot. A lot of weight. The law is clear, though.
Hmm.
The judge does not have to accept a guardian's report.
Okay.
A judge can say, I think this guardian did a good job in evaluating these parties. And I appreciate the recommendation, but ultimately on the court, it's my job to decide I'm going to not go with the recommendation.
Yeah.
Right. And that is tough for a judge to do because, and I don't mean this in a derogatory way, and it might come out that way. The easy thing is for the judge to say, guardian did a great job. I'm going with the report.
Yeah.
Right. You got a guardian. He did all this work. They waived
Yeah.
the hearsay. Here's what they said. They were on the stand and held up to cross-examination. Right. Inevitably, one of the parties is going to attack the guardian for not doing a good job because they ruled against them.
Mm-hmm.
Their recommendations are against them. The other one's going to say, this is the best guardian in the history of guardians. Right?
Yeah, right. Superhero guardian. I get it.
Yeah. Yeah. So it's an interesting dynamic. And sometimes maybe you think the guardian did a nice job, but just got the recommendations wrong. So then as the lawyer, you got to support the guardian in their kind of fact finding,
Yeah, and
but
their effort.
not in their ultimate decisions. So
Can you turn off your bings?
No, dude. If
Is that
I
on your, is
can,
that on your
I
phone?
will.
I think, is your
Yeah.
phone in your
And
pocket somewhere?
it's coming up on, I will quit messages that is on my computer. I'm supposed to bring home milk tonight.
That's what we interrupted the show for. Great.
Exactly.
That's good.
Exactly.
Do you know what? I'm going to DoorDash some milk to your house right now. We're just going to knock this out.
I appreciate that. But turn off your notifications. I don't want to hear that stuff.
All right.
So yeah, so it's a delicate balance, right? And the other thing that we really need to focus on, which is really overlooked, is how do you, the parent, deal with the guardian?
Yeah.
Right? Because what you want to do is you're like, oh, I'm finally someone that's going to represent my kid and can talk to my kid. I'm going to tell you how it is. And you think if you just tell your story, the guardian's going to believe you. I assure you, the guardian has heard this story before with different names ages, children. But when
Yeah.
you've been doing this as long as we have, nothing surprises you.
Yeah.
So you really need to get your thoughts in order. You need to say what you think the root problem is. You need to say what you think the symptoms then are, and what you think you've done well in trying to work through those issues in areas that you think you can improve on. Because you've got some responsibility here. Because
Yeah.
no one's perfect with dealing with a soon to be former spouse or former spouse when you got to get a guardian involved. There's tons of communications. There's tons of text messages or our family wizard message or talking parent messages where you're saying stuff you shouldn't be saying, either to the other parent or to the child, or your social media post.
Oh, yeah. Well, we've talked about that before. Stay off.
Right.
The question I have for you is about the dueling objectives of parents in a contentious relationship. How do you guide? Like I assume you're giving guidance to your client on how to relate to the guardian, and what happens when you know the case and you realize I think they're going to make a bad impression on the guardian when they talk to them. What does that sound like?
Oh, exactly what I just said. I'm
Okay.
going to sit my client down and say, here's the problem. Your heart is right. Your mouth is wrong.
Okay.
Right. You're coming from all the right places, but the way you're saying it, it doesn't sound like it.
Okay.
Right. This is not about how bad a dad is. Right. This is you saying, here's what I think the issue is. Here's how it manifests itself. Here's how I try to deal with it. Here's some mistakes that I've made. Here's where I think I've done well, but it didn't have the desired result. And all of those are going to be communications. It's
Yeah.
all going to be communications. There was a doctor appointment that dad unilaterally set and did not tell me. I didn't find out about it until I got the statement of benefits in the mail that said my child had X.
Yeah.
And I went on a text message and I shot him a picture and I called him all sorts of names because I was frustrated. That was
Yeah.
wrong of me.
Yeah.
Right. As opposed to saying, hey, I got this statement of benefits. I don't recall us discussing going to this appointment, and I didn't see it on the shared calendar. My first concern is everything okay? And my second is, can we, if I missed it, please let me know. But
Yeah.
can we work together to make sure that we're both aware of medical issues in the future?
Right. Let's try to maintain civility.
Yeah. And usually it's like, you didn't even tell me about the appointment. They never ask if the kid's okay.
Yeah. Right.
Right.
Which actually gets to my next question, which is like you mentioned the guardian has a recommendation, and both of the parents, I'm going to assume goodwill and say both of the parents are trying to make the case that they are that they want to spend time with their kids. Let's just say that. What happens when the kiddo comes out and says, I have an opinion. I have agency here, and I want to do something that conflicts with the recommendation of the guardian.
Yeah. Well, the guardian would have had to say, that's what the child told me.
Hmm.
And I didn't agree with it for these reasons.
Hmm.
Right.
Yeah.
The,
I guess, is there any weight to that in court? Dependent, I know, on like, the 6-year-old, you're not going to give him
right.
as much grace as you are, a 17-year-old.
Yeah. And I've had a case with a guardian ad litem. And I don't remember if it was actually a guardian, but the kid came in to testify. And literally the
Wow.
judge goes, everybody here is right. That is a smart, educated, mature child. And there's a court order for him to be in Florida. He needs to come back to Florida.
Wow.
Yeah. And the
Wow.
kid was like in his junior year or senior year or something in high school.
And had
The
to
judge
leave
said,
his high school.
Yep. Yep.
Wow.
So, you
Okay.
know, th-
Who do you finish your
I
thought?
was just about to say that ultimately the kid doesn't get to make the decision.
Yeah.
You know,
Okay. Who bears the cost of the guardian?
uh, it's usually argued about. Judges tend to say one of the following things: we're splitting this without prejudice, which means you both pay for now. We can argue about the money later. But I'm getting this report now from the guardian, and you both are going to split it. Okay.
Yeah.
The second thing the judge can say is, Mr. Nelson, your client wants it. They can pay for it. I'll do it without prejudice. We can argue about it later. But if you want to front the cost, fine.
Okay.
Okay. So when you're asking for something, you better be prepared to pay for it on the front end. You can argue on the back end, but you
Yeah.
better be prepared to pay on the front end.
Okay. And is there any circumstance in which the court orders a guardian and decides who pays for it?
Yeah, they can decide up front, especially if one person has a lot more income than the other, if there's a
Yeah.
huge disparity of income. So there's a lot of different ways that can flush
Okay.
out. But there's very little time. And do you want to spend your time arguing for a guardian in court if you have to go to court to argue about it, about who's going to pay for it, or you
Mhm.
want to argue the substance on why you need it? I'm
Okay.
taking the substance on why I need it every day
Every
of the week
time.
and twice
Yeah.
on Sunday.
Yeah. So I feel like you've given a really solid sort of overview of kind of the threshold interactions with the guardian. But are there any just common fumbles you see parents make when dealing with a guardian that we need to know about?
Always blaming the other.
They
Always
write
blaming
that
the
they
other
write that
side.
down in their little book.
Yeah. They're
Okay.
always blaming, like, and the guardians, they do this all the time. They can read through this and they'll get the lawyers on the phone and say, here's the problem.
Yeah.
It will be Tuesday, and one will say it's Wednesday, the other will say it's Monday.
Okay.
So we're not going to get anywhere here. And my
Yeah.
report's going to say these are two of the worst parents I've ever seen. Judge, here's my recommendation, but it's not going to help this kid.
Yeah.
And then what does the judge do?
Do you have any other parents you could recommend that would take this child?
That's right. And then they say, you know what? There's this podcast called The Toaster. and, and there are two guys there that seem to like kids.
Yeah, take him. The toaster will start adopting, fostering kids.
But only from poorly litigated
Yeah.
parenting cases, not
You,
regular foster care.
we didn't mention this up front. You said kind of as a side comment that they could be an attorney, the guardian, but I don't think we ever specified what qualifications are there, if any, that are required to become a guardian.
Yeah, so there's some courses you can take, right? Mental health professionals can be guardian, it listed in the statute, and being a member of the Florida bar is one of them.
Okay.
So, but there's some really, really great people out there that have taken courses and just
Yeah,
do this for kids. And you don't, it's one of those jobs, overworked, underpaid.
of course.
Yeah, it's really great people out there with good hearts that care about kids that do it.
And very well supported by you as an attorney.
Oh, if we can get a good one, we do it. Now,
Yeah.
sometimes the court, there's usually two types of guardians in their professional backgrounds. One is mental health professional, and the other ones will be lawyers that have litigated these issues. Because
Mhm.
we've seen the issues. We care about kids, despite what people say about divorce attorneys. And so you're trying to get there and help people. And it's really interesting to me because when you talk to a lawyer, what they can do is do the analysis on the factors that the judge is going to do. They can see how it's going to play out in court.
Yeah.
Right. And they know the weaknesses of the case. They know the weaknesses of the parents. They know the weaknesses of their own report. And they'll say, yeah, judge, I didn't really get everything I needed from mom because every time I asked for something, mom stonewalled me. And if I can't get it, I'm siding for dad. And
Yeah.
these dads, moms that I'm using are interchangeable. So,
Yeah.
so those are kind of the backgrounds. The mental health sometimes is really good at identifying the problem, but people usually go into mental health treatment to help people come together. And ultimately, this is an adversarial position. And so sometimes they're a little bit kumbaya ish.
Mhm.
Like if they could just get along, well, no shit.
Yeah.
Like, of course, if they could
That's
just
the
get along,
point.
we wouldn't be here, right?
Right.
So it's not that they're coming from it being naive. They just see the path if the parents would take the steps to get along.
Mhm.
Where sometimes I think that's a distraction, where sometimes the lawyer's like, this is what I think is best for this kid, and here's why.
Yeah.
Right? They're kind of more firm
Matter of
about it.
fact. Yeah.
You know,
Okay.
it's not right or wrong. It's just a different approach.
Super useful, Seth.
Well, thank
What
you.
can I say?
Thank
Yeah.
you. Well, we'll see what Andy says. Sorry for the notifications. It turns out we had milk.
Thank goodness. Oh my gosh. Call off the I gotta get on DoorDash now. I gotta call them up. Do you want anything else? They're at the store.
No, we're good. Thank you.
Thank you, everybody, for downloading and listening to this show. We sure appreciate your time and your attention. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll see you next time right here on How to Split a Toaster, a divorce podcast about saving your relationships.
Just pulled on the